Hello. Probably you heard that if your court application in the court of the first instance, be it a court of Quebec or Superior Court of Quebec, is held abusive, then to appeal from that decision, you need a special permission from the Court of Appeal, so-called leave to appeal. But there is an interesting nuance in there. It might be that you want to appeal if you were a defendant, not a plaintiff, in this decision. And even if, as a defendant, you were held abusive, still, according to the Court of Appeal in Matt Contley decision 2019, still you have a right to appeal. So your appeal is as of right. You don't need a leave to appeal. You don't need a permission. Because according to the Court of Appeal, this requirement to ask a special permission, to ask for a leave to appeal, only applies to plaintiffs, to those who brought up the judicial application, the originating application, not to those who were bringing up anything else, any other kind of a procedure, but for a cross application. Because according to the Court of Appeal, if you bring up a cross application, that makes you a plaintiff. And then again, if you're held abusive for that cross application or in that part, then you would require permission. But if you are just a defendant, as the court specifically mentioned, even though it might seem counterintuitive, but that was the legislative intent, because the legislator specifically said that this requirement applies to those who brought the judicial application. So if you're just a defendant without a cross application, then you can appeal as of right, even if you were held abusive. Thank you, and have a nice day.